I would like to acknowledge the Darug people, the traditional custodians of the land from which I am speaking today. I pay my respect to elders past and present and extend that respect to any Aboriginal and Torres Strait Islander people watching this premiere tonight. Although it is disappointing that we are unable to celebrate in person, I am very pleased to be introducing the launch event for issue 44.2 of the University of New South Wales Law Journal virtually. While we had big plans to host our first in-person launch event since 2020 at the Sydney offices of Herbert Smith Freehills, one of the journal's premier sponsors, I am immensely grateful that we are able to film and arrange for a virtual launch event to mark the publication of issue 44.2. The journal is also extremely thankful for the support that Herbert Smith Freehills has provided us over the years as one of our oldest sponsors, particularly these last 2 years, where your flexibility and willingness to accommodate us have been much appreciated. I would like to thank in particular Rachel Koch for your assistance in preparing for this launch, and Rebecca Gay, partner at Herbert Smith Freehills, for offering to deliver the welcome to the firm. I would like now to congratulate Rebecca Zoll, the editor for issue 44.2, for bringing together this issue. As some of you may or may not know, Rebecca and I are actually old friends. We went to the same high school, we're in band together, we shared the same drama class. That's why I was so excited to learn that we would be working together when I first came into this role as executive editor. I'm so proud to be able to share this achievement with her. Throughout the publication process, Rebecca was nothing but organised, professional, and just a delight to work with. I am so excited to see where she'll be headed next. I'll leave it to Rebecca to talk about the contents of her issue, but suffice to say, I was very pleased to learn that the lead article for this issue is UNSW's Professor Michael Handler's article, Trademark Law's Identity Crisis Part 2. Not the least because I thoroughly enjoyed Professor Handler's lectures on trademarks when I was taking intellectual property law last year. Now I would like to thank our keynote speaker, the Hon Justice Steven Rares of the Federal Court of Australia. I greatly look forward to hearing your speech, and I have no doubt that your wisdom and expertise will be extremely informative and enlightening to our viewers. I would also like to extend my thanks to each and every author who is published in this issue. Thank you for entrusting the journal with your work and for making our publication possible. I wish you all the best with the rest of your academic career. Thank you to the UNSW Law School for your continual support of the journal. I would like to express my gratitude in particular to Professor Andrew Lynch, Dean of the UNSW Law and Justice Faculty, who will be delivering the vote of thanks. Congratulations also on your recent position as the Dean of the Faculty, after a marvellous tenure as Acting Dean. I am also extremely grateful to our faculty advisors, Professor Rosalind Dixon and Professor Garrett Edmond, for your time, advice and encouragement in the day-to-day running of the journal. Thank you for always having the best interests of the journal at heart. Special thanks must go to the rest of the Executive Committee, and I would like to congratulate in particular Akriti Shori, editor of issue 45.2 and Rebecca's successor. I'm very lucky to be working with you all, and I couldn't have asked for a better executive for the journal. Lastly, but definitely not least, I would like to extend a huge thank you and congratulations to the General Editorial Board. Your resilience during this difficult time, especially when we lost access to libraries and obtaining physical sources became almost impossible, has not gone unnoticed. I hope you enjoyed the virtual launch event and the small token of appreciation that we have shared with you. Without further ado, I would like now to hand over to Rebecca Gay, partner at Herbert Smith Freehills, to welcome us to the firm.
Hello, my name is Rebecca Gay and I'm a partner at Herbert Smith Freehills, and it's my pleasure to welcome you to this special virtual launch of Volume 44, Issue 2 of the University of New South Wales Law Journal. I'd like to begin today by acknowledging the traditional owners of the land from which I'm giving this welcome, the Gadigal people of the Eora Nation, and I pay my respects to their elders past, present and future. Herbert Smith Freehills and the Journal have quite a long history which goes back some 38 years, and HSF's also the very proud sponsor of the UNSW Law Library, where I, as an undergraduate and a postgraduate, student, spent many hours. And of course, HSF's been lucky enough to have many fantastic alumni of UNSW work with us over the years. So it is a shame that this particular launch can't happen in our offices. We can share each other's company, but I'm sure there will be many opportunities in the future, I should say, to welcome you to our offices. As an IP lawyer, this particular issue of the journal is, of course, real interest to me, with a theme around reconsidering Australian intellectual property law, and with Professor Handler presenting a series of articles in which he addresses what he calls trademark law's identity crisis. Some may say that really means we should be calling in the psychologists, but Professor Handler helps unpack for us some complex issues around substantial identity and deceptive similarity. In a short while, we're also going to be lucky enough to hear from the Honourable Justice Rares. So I will now hand over to Rebecca Zong, who is the editor of the journal and who will introduce us to this particular issue. Thank you and welcome again.
Thank you, Rebecca, for your introduction, and hello to everyone, wherever and whenever you're watching this from. Although I expected to be meeting you all in person, I'd like to thank you for tuning in to our virtual launch. I'd like to begin by acknowledging the Darug people, traditional custodians of the land on which I am speaking today, and pay my respects to the elders past, present, and emerging. Well, first, I guess I should address the elephant in the room. That is, we're not actually in a room together. When I was first writing this speech, just under 3 months ago, there was a small voice in my head that said, maybe an unexpected outbreak will happen and we'll have to do this virtually. Maybe you should consider writing 2 versions of this speech, including one that doesn't make so many references to us all being together, and isn't it so nice to be able to shake hands with people again, and aren't the canapes great? I thought, nah, it'll be fine. We're only a week out of the launch, what could possibly happen between now and next Thursday? Oh, how wrong I was. But I'm grateful that we're nevertheless able to celebrate the work that has gone into Volume 44, Issue 2 of the UNSW Law Journal, albeit virtually. I'm proud to be launching Issue 44.2, which is a general issue containing 12 articles canvassing a spectrum of issues, important topics relevant to the Australian legal landscape today. The theme of the launch, Reconsidering Australian Intellectual Property Law, is based on the lead article of this issue, authored by Professor Michael Handler. Professor Handler's article is in fact in 2 parts, the second of which is in this issue, the first being published in the previous issue 44.1. In the article, Professor Handler analyses the concept of substantial identity in trademark law and goes on to strongly criticise the Federal Court of Australia's recent disruption, as he puts it, of this doctrine, leading to unjust and undesirable consequences. This article is exemplary of the kind of thoughtful and provocative scholarship that the journal is so proud to publish. Trademark and intellectual property law is also an area of great interest to me personally, and I hope that Professor Handler's article, as well as Justice Rares' keynote address, which will follow, inspire meaningful debate on an important area of law. The other articles in this issue are similarly exciting and thought-provoking. Some articles challenge the status quo. For example, Tegan Cohen examines the corrosive effects of the political exemptions in the Privacy Act on privacy and democratic values. And Julia Quilter and Russell Hogg consider the serious ancillary harms of mandatory helmet laws in New South Wales. Other articles venture into new or previously overlooked issues, such as Emerson Hynard and Aidan Lurch's compelling analysis of the tort of collateral abuse of process, and Daniel Reynolds' investigation into the history and future development of the little-examined Section 117 of the Constitution. Clearly, then, the articles in Issue 44.2 stem from a wide array of legal backgrounds and perspectives. The journal is incredibly lucky to be able to publish such interesting scholarship, and I hope those of you who have already got your hands on a copy of the issue will enjoy reading it as much as I enjoyed the editorial process. Of course, the issue would not exist without the support and hard work of many people. It has been said that laws are like sausages. You should never see one being made. But I would venture to say that the opposite is true for law journals, and I'd like to take this opportunity now to thank all those who have so generously contributed their time and labour. First of all, I'd like to thank the authors for entrusting us with their stellar contributions. Thank you for your patience throughout the process and for taking on board the suggestions from the editors with such good grace. It has been a privilege to work with you, and I am humbled and incredibly grateful to have been able to assist in the publication of such remarkable scholarship. Thank you also to the peer reviewers whose invaluable comments allow the journal to continue to publish exciting articles at the forefront of Australian legal academia. My next thanks must go to the editorial board, 50 or so of UNSW's best and brightest. I'm deeply indebted to all of you for the long Saturdays and the hours spent looking for old UK parliamentary reports, the relevant pages of which somehow always come after the Google Books free preview has ended. I think you can and should be proud of what your efforts have resulted in. I have also had the privilege of working with some exceptional individuals on the executive committee. No one knows this process like you guys. Thank you for your support, understanding, and friendship. I'd also like to thank the UNSW Faculty of Law and Justice, in particular Professor Andrew Lynch, Dean, and the journal's faculty advisors, Professors Rosalind Dixon and Gary Admond. Their wisdom, trust, and guidance has allowed the journal to remain one of Australia's only entirely student-produced academic legal journals. I'd like to also extend my gratitude to the UNSW Library and librarians, whose assistance has been invaluable, particularly during the lockdown period. My thanks must also go to the journal's premier sponsors, Herbert Smith Freehills, Allens, and Kingwood Mallisons. I would especially like to thank Herbert Smith Freehills for supporting the Issue 44.2 launch, and in particular Rebecca Gay, partner and joint global head of intellectual property, for agreeing to speak today. I also want to thank my family and my friends, and to apologise for my distractedness and the emotional labour I've no doubt burdened them with over the past year. Thank you for your generosity, optimism, and love. Finally, I'd like to thank Justice Rares of the Federal Court of Australia for agreeing to deliver the keynote address today. His Honour has been a judge of the Federal Court of Australia since 2006 and is also an additional judge of the Supreme Court of the Australian Capital Territory and a judge of the Supreme Court of Norfolk Island. Justice Rares is a judge in the Intellectual Property National Practice Area in the Federal Court, and I am very grateful that he will today be speaking on the theme of the launch, Reconsidering Australian Intellectual Property Law. It is my pleasure to now invite His Honour to deliver the keynote address. Thank you.
I am delighted to launch, unfortunately only virtually, this issue of the distinguished University of New South Wales Law Journal. The editors have had to confront more than the usual obstacles to produce and set this issue on course due to the effects of the pandemic and the now 3-month-long lockdown in Sydney. The theme of this issue is intellectual property. Intellectual property, like much in life, is not always found in the cerebral world. Its practical application and uses are evident in our daily lives, from the mundane to items such as a mobile phone that's now inseparable from us from the age of about 6 months, to the moment when we face Hamlet's question, not necessarily as with him a matter of choice, of to be or not to be. In the law, disputes relating to intellectual property generate other weighty questions, such as the issue that once perplexed the Seventh Circuit Court of Appeals in Georgia Pacific Consumer Products LP and Kimberly-Clark Corporation. It had to decide whether the use of a quilt design embossed on toilet paper provided, quote, utilitarian benefits, such as softness, bulk, comfort, absorption, and, quote, non-nesting properties, that amounted to infringement of patent or trademark rights. Judge Evans, delivering the reasons of the Court of Appeals, began by saying, toilet paper. This case is about toilet paper. Are there many other things most people use every day but think very little about? We doubt it. But then again, only a select few of us work in the rarefied air inhabited by top-rate intellectual property lawyers who specialise in presenting and defending claims of unfair competition and trademark infringement under the Lanham Act. 15 United States Code, section 1051, et sec. And the lawyers on both sides of this dispute are truly first-rate. Together they cite some 119 cases and 20 federal statutes, albeit with a little overlap, in their initial briefs. We're told that during the, quote, expedited discovery period leading up to the district court decision, we called upon to review, some 675,000 pages of documents were produced and more than a dozen witnesses were deposed. That's quite a record, considering again that this case is about toilet paper. Contemplating what one could say on such topics brought to mind how Hamlet dealt with the similar torment in that speech as I thought of the toilet paper case. To die, to sleep, perchance to dream. Aye, there's the rub. Perhaps counterintuitively, the law does not recognise any proprietary right in mere knowledge. Thus, if a client pays a lawyer, B, to use his or her skill and faculties to acquire knowledge and apply it while keeping that knowledge confidential in the client's interests, neither the client nor the lawyer can prevent another lawyer, who had no dealings with either of them, from independently using his or her own skill and knowledge to achieve or discover the same result B had. As Chief Justice Latham said in Federal Commission of Taxation United Aircraft Corporation, knowledge cannot be described as property except in a metaphorical sense. The lawyer's original idea to use an argument in a case in itself, however brilliant, is not property. Thus, a lawyer who thinks of a fantastic or original point that he or she envisages will help his or her client cannot prevent someone else running the point well or badly before the originator gets his chance. What the law does protect, however, is the original expression of an idea through the beguiling matrix of intellectual property rights. You can patent something that's useful and is a new invention so long as it is a method of manufacture. You can protect trademark that consists in the exclusive right to a distinctive mark that conveys an association with you, your product or service, and you can claim copyright, being the exclusive right to reproduce an original work that you've created, such as a book, artwork, film, video, or web page. Thus, in O'Brien and Komisarov, the High Court established that the lawyer can prevent you copying his or her expression of ideas in a unit trust deed or corporate constitution that he or she drafted. That is so even though each document contained much public property or common knowledge. But while the lawyer may have utilised considerable skill and ingenuity in producing those documents, if he or she wishes to establish, at basis apart from breach of copyright, that they contain information that the law would restrain being used, he or she must establish that another person's use of the ideas would involve use of the lawyer's confidential information or clients. Thus, a lawyer who by way of advice regularly publishes to clients documents such as unit trust deeds and corporate constitutions, no doubt adapted to the individual client's circumstances, but based on common knowledge of what such documents contain, must point to something more than the fact that he or she wrote the documents. As Justice Mason explained, it's a fundamental problem with the information which the respondent seeks to protect, that is information which, by way of advice to others, he regularly publishes to the world at large, albeit for a limited purpose. The nature of such information ill accords with the accepted conception of confidentiality, which in substance involves the person seeking to protect information largely keeping it to himself. Justice Mason said, to simply say that the information is as to the effect and practical operation of discretionary trusts and private unit trust schemes does not identify the information and enable the court to formulate an order. One needs to know not only what was the information conveyed, but also what part of that information was not common knowledge. So, although our creative lawyer may have difficulty seeking to protect his or her idea from being exploited or ruined by someone else, the lawyer has other uses that, at least in the legal profession's eyes, those uses would make it unwise to follow up the famous formula to create an ideal state coined by Dick the Butcher in another Shakespearean tragedy, Henry VI. The first thing we do, let's kill all the lawyers. Intellectual property law covers a wide field. It can appear intimidatingly technical to the uninitiated novice. Often one can pass off some knowledge as sufficient. Recent decisions of the Federal Court, on which I sit, have considered products that competing businesses and their lawyers argued were discernibly similar or distinct, depending on which side of the coin one was, such as the following that became exhibits: beer bottles in Urban Allen Brewery and La Sirene 2020, burger wrappers in #burgers and in-out burgers, again last year, and garlic bread packaging in Goodman Fielder and Conger Foods. Beer has been quite a regular player in these disputes. A few cans of Homer Simpson's Duff beer, which you may recall from watching The Simpsons Needs More Dog, have survived as souvenirs from 20th Century Fox Film Corporation and South Australian Brewing Co. Limited, that Justice Tamblyn decided in 1997. The courts will also enjoin one trader passing off its goods or services as those of a rival. In Thomas Montgomery and Thompson, Lord Macnaghten, with his customary pungency, discussed the terms of an injunction granted against a fraudulent trader who'd set up a new brewery business in the town of Stone. The plaintiff had for a century carried on its business there and had for many years been famous for producing ales known as Stone Ales, a name the defendant applied to the products he produced, quote, in the hope of reaping where he had not sown. His lordship said of the defendant, "It would have been impossible for him to have called his ales Stone Ales and to have distinguished his ales from those of the plaintiff. Any attempt to distinguish the two, even if it honestly meant, would have been perfectly idle. Thirsty folk want beer, not explanations. If the public get the thing they want, or something near it, and get it under the old name, the name with which they're familiar, they're likely to be supremely indifferent to the character and conduct of the brewer and the equitable rights of rival traders." The topics that I propose to discuss in this paper are the boundaries of the patentee's monopoly in two areas of use of a potential invention. One area is unsettled, being the prior use defence under Section 119 of the Patents Act 1990, the other being recently settled, namely the exhaustion doctrine, as the High Court determined in Caladad Pty Limited and Seco Epsom Corporation. What happens when a person is already making a product using a method or process for which someone else obtains a patent? Can the other person continue what he, she or it was doing before the grant of the patent, or will that conduct constitute an infringement of the patent? Section 119 of the Patents Act provides a defence to a claim for infringement of a patent. Lord Diplock described the general law position in Bristol Myers Co. and Beecham Group Limited in 1974 Appeal Cases 646, saying that, quote, "From earliest times it's been taken for granted that by the phrase seemingly manufactures which others at the time of making such letters, patent and grants shall not use, it was intended to declare unlawful the grant of any patent which would put it into the power of the grantee to prevent any other trader from doing whatever he or had done before in the course of his trade. The right of a trader," his lordship continued, "to go on dealing by way of trade in any man-made substance in which he had dealt before without impediment by monopoly in that substance granted to another person was not dependent on his knowledge of its composition or how it could be made. If he'd in fact dealt in the substance, he'd used it. His ignorance of those matters was irrelevant to the question of his use." In 2005, Justices Hill, Finn and Giles held that the pre-2006 form of Section 119 of the Australian Act dealt with the principle that his lordship described, namely that a person cannot be prevented in, quote, "a restricted fashion," close quote, from doing what they were doing prior to the grant of the patent. An offence of prior use is provided in Section 119. It's not itself had much prior use. Indeed, prior use exemptions have received very little attention in any jurisdiction. The current form of this defence provides that if immediately before the priority date of the relevant claim in the patent, a person was exploiting the product, method or process in the patent area, here Australia, or had taken definite contractual or other steps to do so, Section 119(1) enables the person to continue to do that act without infringing the patent. However, the defence will not apply if, before the priority date, the person had stopped exploiting or abandoned the steps to exploit, except temporarily, the product, method or process in the patent area. For the purposes of the defence, Section 119(5) defines exploit as including making, having, selling, offering for sale, using or importing a product, or as using a method or process and then doing any of the above acts with the resulting product. In 1998, Lord Justice Aldous described the purpose of the English analogue of Section 119(1)A. He said that the defence it provided was to preserve, despite the grant of a patent to a third party, the right of a person who at the priority date is already engaging in a commercial activity to continue to engage in any means of exploitation of that activity that would otherwise infringe. The trial judge in that case, Justice Jacob, a very experienced patent judge, had discussed the concept of commercial activity in the sense that Lord Justice Aldous later considered. Justice Jacobs said that in the circumstances, including technical and commercial matters, had to be considered in deciding whether the alleged infringing activity was substantially the same as what the alleged infringer had been doing before the grant of the patent created the potential for infringement. He said that this, quote, is important in a case where there are inherent minor variations in starting materials or the like. If the protected act has to be exactly the same, whatever that may mean, as the prior act, then the protection given by the English section would be illusory. The section is intended to give a practical protection to enable a man to continue doing what in substance he was doing before. Importantly, section 119(1)(a) appears to operate if the person engaged in any act of exploitation of the product or another commercial activity, such as the importation of or offer to sell a product before the priority date. That section allows the person not merely to continue to do that act, but also to do any act that exploits the product. The right that section 119(1)(a) confers is in terms relevantly to do an act that exploits the product, as, quote, exploit is defined in section 119(5) without infringing the patent, provided that the person immediately before the priority date was exploiting the product. Thus, any act by which the person was exploiting the product will create a right, despite what would otherwise infringe the patent, to, quote, do an act that exploits the product, close quote. Unless this was so, a person who'd imported a product before the priority date could continue importing but could not sell it afterwards, which would sterilise the preservation of the right to import. Indeed, this also follows from section 119(1)(b), which ordinarily would give the importer the right to exploit the product because that person is likely to have taken, quote, definite steps, close quote, contractually or otherwise, to exploit it. In Vehicle Monitoring Systems and Saab Management Group Pty Limited, trading as Database Consultants Australia number 2, 101 Intellectual Property Reports 496, Justice Yates observes that the defence under section 119(1) was limited to the alleged infringer's own acts that exploited a product, method or process in a way that would infringe a patent, and did not extend to the alleged infringer authorising another person to exploit the invention. The learned authors of Lahore, Patents, Trademarks and Related Rights commented that his Honour's construction of section 119(1) appeared first to contradict the purpose for which the Parliament enacted section 119 in substantially its present form in the Intellectual Property Laws Amendment Act 2006, and secondly did not refer to section 117, which equates use of an infringing product with its supply in the context of how section 119 might operate. The explanatory memorandum for the 2006 bill that was enacted stated, in paragraphs 131 to 133, the reference to product, method or process is intended to cover everything that could be covered by a patent. It's intended to be construed expansively and is not intended to limit the operation of the section. As a result of this amendment, if a person had, before the relevant priority date, been doing one act that would have constituted exploitation of a product, method or process, for example, if they'd been making a particular product or using a particular method or process, then even when the patent had been granted, they'd have had a right to continue to do that act. But, in addition, they'd have the right to do any other act that would constitute an exploitation of that product, method or process. For example, they have the right to sell the product that they've been making, or to sell a product resulting from using the method or process. In paragraph 136 of the explanatory memorandum, the authors said, subsection 4 allows the prior user to assign the whole of his or her prior use right under this section. The assignee may then have the full benefit of the prior use exemption. There's no provision for the prior user to license his or her prior use right. This raises a question, particularly now in light of the High Court's decision and the meaning of exploit in section 113 and the dictionary in the Patents Act in Caledad, whether Justice Yates's construction of section 119(1) may be too narrow. Of course, section 119(5) has a bespoke definition of exploit as used in section 119 itself. There could be some force in the argument section 119(1) should be construed broadly to authorise a purchaser from a person entitled to exploit a product method or process in accordance with Section 119 to use the product, else the right of the vendor to sell it to the subsequent purchasing user would appear to be illusory. A narrow construction would effectively sterilise the ability of a wholesaler or distributor who had been importing a product from selling it to a new retailer, that is, one in addition to those retailers which the importer had previously supplied, after the grant of the patent, because the retailer would infringe by offering the product for sale or reselling it, as would the consumer who acquired it and then used it. The ordinary natural meaning of Section 119 appears to allow the person to whom it protects to do anything to exploit the product, method or process, and thus to authorise a purchaser of the product to use it. Unless that was so, the patentee could threaten infringement proceedings against any potential or actual purchaser of a product offered for sale or sold by the person entitled to the Section 119(1) right, so that no effective sale could ever be made, despite the express authority of the Parliament for the person to exploit the product by way of offer or sale of a product to which Section 119(1) applies. The second important aspect of Section 119 is Section 119(4). That provides that a person can dispose to another of the whole of the disposer's entitlement under Section 119(1) to do an act without infringing a patent. The subsection gives the disponee the same rights as the disposer or any predecessor entitled of the disposer who had an entitlement under Section 119(1). The natural and ordinary meaning of Section 119(4) appears to convey that the only way in which the disposer can dispose of the whole of the disposer's entitlement under Section 119(1) is by an assignment to the recipient. A legal shows in action may be transferred by an assignment in writing under Section 12 of the Conveyancing Act 1919 of New South Wales and its analogues derived from Section 25(6) of the Judicature Act 1873 of the United Kingdom Parliament. However, equity did not require an assignment of property, including a legal shows in action, to be in writing, provided that the property was capable of being assigned under the principles of equity, as explained by Justice Windiger in his classic judgment in Norman and Federal Commission of Taxation. He said, assignment means the immediate transfer of existing proprietary right, vested or contingent, from the assignor to the assignee. In Halloran and Minister administering the National Parks and Wildlife Act 1974, Chief Justice Gleeson, Justices Gummo, Kirby and Haynes said, where an interest is to be transferred, as here, a creature of equity, equity requires a clear expression of intention to make an immediate disposition, that in the absence of an explicable statutory entitlement suffices. See Norman. If the transaction is a contract rather than a conveyance, then consideration is essential to attract the support of equity. Again, see Norman. It may be that Section 119(4) requires the disposer to transfer the recipient by writing or by some other identifiable act the disposer's entitlement under Section 119(1), so that from the moment of the disposition, the recipient may exercise the statutory right as it pleases, and the disposer cannot ever do so again. While the sale of a product by a prior user could satisfy Section 119(4) without requiring specific documentation to protect a purchaser, it's difficult to think of practical examples in which a disposition of entitlement under Section 119(1) to do an act that exploited a method or process could occur without a contemporaneous document recording that fact. However, it may be possible that circumstances may arise from which a clear, unmistakable inference could be drawn from the disposer's acts or conduct that the disposer had transferred its entitlement to the method or process under Section 119(1) once for all to an intended recipient. The terms of Section 119(4) replicate what Lord Newberger of Abbotsbury, PSC, President of the Supreme Court, said in Ackers and Sandbrook Financial Group, namely that a disposition normally involves a disponor and a disponee. Thus, it's likely that a person relying on a disposition of a method or process under Section 119(4) will have to identify some act by the disposer by which it disposed of its entitlement under Section 119(1) to some third-party disponee called the recipient in Section 119(4). I'll return to Section 119 later. The exhaustion doctrine. Last year in Caledad, Chief Justice Kiefel and Justices Bell and Keane, together with Justice Gagler, over the dissent of Justices Nettle, Gordon and Edelman, held that a patentee's rights under Section 13 of the Patents Act to exploit an invention, which is a product, namely the rights to make, hire, sell or otherwise dispose of or use the product, are first exhausted when it's sold, and secondly, not infringed if a purchaser of the product modifies it so as to enable it to be reused. In that case, the patentee of Epson printer ink cartridges, as responded in the High Court, must have thought it was on solid ground. However, it would seem that the ink was not yet dry on this area of intellectual property law. That was because since 1911, the decision of the Privy Council and National Phonographic Company of Australia Limited, NENC, which had overruled the High Court, determined that a patentee's statutory monopoly enabled it, at the time of the sale of its products, to impose conditions that restricted the purchaser's right to sell or use the product, and that such a restriction bound any subsequent owner or user who knew of the restriction. Counsel for the respondent were in the position described by Lord Russell of Culloden in his dissenting speech at Sudbrook Trading Estate Limited in Eggleton, where he wryly said, tracking back again to the Bard, "I felt considerable sympathy for counsel for the respondents when he was told that he had all the law on his side but was in effect facing the profits." This is a paraphrase of my own remark and argument when he was told that he had all equity behind him, and I intervened to suggest that he had less in front of him. In the result, I dismissed the appeal. I can only explain with Macduff what all my pretty chickens and their dam at one fell swoop. The advantage of making a speech about the law is that one can speculate or float ideas without being accountable to the profits or even held to it if counsel cite one's words back to one in submissions. Returning to Caledad, Chief Justice Keefe, Justice Bell and Keane noted that in Impression Products Inc. and Lexmark International Inc., Chief Justice Roberts, giving the judgment of the majority of the Supreme Court of the United States of America, said that the plaintiff, quote, had exhausted its patent rights in the cartridges the moment it sold them. Their Honours acknowledged that the single-use, no resale restrictions in Lexmark's contract with its customers may be enforceable under contract law, but they did not entitle Lexmark to retain patent rights in an item that it has elected to sell. Chief Justice Roberts explained, and the majority of the High Court adopted, that the exhaustion doctrine was not a presumption that arises on sale, but rather it recognises a limit on the scope of the patentee's statutory rights. His Honour said that a patentee is free to set the price and negotiate contracts with purchasers, but may not, quote, by virtue of his patent, control the use or disposition of the product after ownership passes. After acknowledging that the effect of a patent is to grant a patentee a right to prevent others from using or selling a product, His Honour explained that the exhaustion doctrine regards that exclusionary power as extinguished when the product is sold. Chief Justice Roberts reiterated that what earlier cases had held, namely, when a patentee chooses to sell a patented product, the product is, quote, no longer within the limits of the monopoly, close quote. Instead, the product becomes the private individual property of the purchaser with all the rights and benefits of ownership. Chief Justice Keefe, Justice Bell and Keane referred to the important distinction between the patentee's right to make the product the subject of a claim in a patent and the right to sell or use such a product. That was crucial in understanding whether when Caledad's supplier made the modifications to the patented printer cartridges, it infringed the patent held by Seiko Epson Corporation, the patentee. They found that by making and later resealing small holes in an empty Seiko printer ink cartridge to allow it to be refilled with ink and reprogramming the memory chip, forming part of the cartridge so that the refilled cartridge could be reused, Caledad's supplier had not caused the product as originally sold to cease to exist. The Honours found that these modifications did not involve a replication or remaking of parts or features of the invention as claimed, and that, quote, there was no true manufacture or construction of a cartridge which embodied the features of the patent claim. Rather, Chief Justice Keefe, Justice Bell and Keane characterised those modifications as being consistent with the rights of the owner of a product to alter it so as to improve its usefulness and enable its reuse or to prolong its, quote, life. They explained their policy reasons for preferring the exhaustion doctrine to the doctrine of implied license, saying, quote, "The exhaustion doctrine has the virtues of logic, simplicity and coherence with legal principle. It's comprehensible and consistent with the fundamental principle of the common law respecting chattels and an owner's rights respecting their use. At the same time, it does not prevent a patentee from imposing conditions and restrictions as to the use of a patented product after its sale, but simply requires that they be obtained by negotiation in the usual way and enforced according to the law of contract or in equity." Their Honours approached the construction of the patentee's rights under Section 13.1 by noting that the grant of the patent did not give the patentee positive rights to do what he, she or it could do anyway. Rather, the Patent Act gave the patentee negative rights, that is, the rights to exclude or prevent others from manufacturing in a particular way or using a particular invention. Chief Justice Keefe, Justices Bell and Keane, rejected the alternate construction of the patentee's rights under Section 13.1 of the Patents Act based on the Privy Council's reasoning in Mink, as involving the patentee granting the purchaser an implied licence that could operate on sale or use of a patented product, subsequently to restrict how the purchaser used or resold it. Their Honours emphasised that the implied licence doctrine was based on a legal fiction that postulated that the patentee and purchaser agreed by implication to a limitation on the latter's ordinary proprietary rights to use or sell his, her or its personal property in a product that he, she or it had purchased. They said the implied licence doctrine is likely to cause confusion in part because it combines a fictional licence with the possibility of real restrictions. Whilst it seeks to provide the purchaser of patented goods with the full rights of ownership, it leaves open the possibility that there may be other restrictions which may have been notified by the patentee. It engenders uncertainty. Justice Gageler agreed with the joint reasons. He elaborated on them, saying that the exhaustion of rights doctrine has a lineage that is decades longer than the lineage of the implied licence doctrine. It's been shown by repeated application in the United States to be workable and coherent. It sets clear statutory boundaries. It respects long-standing common law principle. It does not need to enlist equity in some way to prop it up. It strikes an appropriate balance between the interests of patentees and the owners of patented products. In doing so, it fits comfortably with the statutory object of the Patents Act as well as with the statutory language. In dissent, Justices Nettle, Gordon and Edelman said that, quote, "Stripping patentees of rights which they've held for more than a century, based on Mink, is a question for the legislature, not the courts. This court should not make such a significant change in the rights of patentees, let alone in an appeal, where the decision of the point is not necessary to resolve the appeal. Resolution of the question does not affect the disposition of the litigation between these parties and, unsurprisingly, the adverse effects of such a change upon commercial arrangements negotiated by reference to these long-standing rights and remedies were not addressed." Their Honours considered that the patentee's exclusive rights under Section 13 to authorise another person to exploit an invention was significant to their conclusion that the implied licence theory in relation to a product ought prevail. They said that the construction of Section 13 should not be confined to its prohibitory or exclusionary effects. They reasoned that the negative right in Section 13 to exclude others from exploiting the patentee's invention carried, quote, "with it the consequence that others do not have the ordinary liberty to make, use, exercise and sell the patented article." Their Honours thought that such a construction gave, quote, "full measure to both elements of the expression negative right, being rights of monopoly." Accordingly, they held that the patentee sold the product with an implied licence, that the buyer could dispose of it as the buyer saw fit, but that the sale did not otherwise exhaust the patentee's rights in relation to the actual product, the subject of the sale, and they applied the conclusion of the Privy Council in Mink in doing so. The minority also emphasised that patent rights are statutory and that concepts opposite to their application in one nation should not be seen as being readily capable of being appropriated to another nation's statutory patent regime. They emphasised that the exhaustion doctrine was a product endogenous to the legal systems in which it had developed, and in particular those of the United States of America and some European jurisdictions. In distinguishing the Supreme Court of the United States decision in impression products, thereon said that the exhaustion doctrine, quote, proceeds from the stated premise that in any sale the patentee cannot assign or devolve, as a matter of patent law, the right to use or sell because, quote, the sale transfers the right to use, sell or import because those are the rights that come along with ownership, close quote, and thus, quote, the bar is free and clear of an infringement lawsuit because there is no exclusionary right left to enforce, close quote. This reflects, they said, the different understanding of a differently framed patent statute. By contrast, the Australian Patents Acts and the courts have made plain that the patentee has the rights to exploit the invention and that those rights may continue beyond sale. Does the decision in Caledad affect the construction of Section 119? The prior use defence in Section 119 is differently expressed to Section 13, and in particular Section 119 does not extend to the prior user having the power that Section 13.1 confers on a patentee, quote, to authorise another person to exploit the invention. However, as I've noted above, Section 119.4 does allow the prior user to dispose of the right to do an act that does not infringe another's patent, where the disposer was exploiting, within the meaning of Section 119.5, a product or using a method or process immediately before the priority date of the relevant claim in the patent that would otherwise infringe it. The exhaustion doctrine, in accordance with the majority's decision in Caledad, arguably could be applied as follows. A prior user, by selling a product in circumstances that attract the prior use defence in Section 119.1, might be thought also to dispose of to the purchaser the disposer's right to exploit that particular product. It could be argued, of course, that this suggestion involves an implied disposition without any writing signed by the disposer or vendor or prior user. Yet how else is the disponee or purchaser of such a product able to use or resell it unless he, she or it has a concomitant protection under Section 119.4 as the prior user had? Nor would the right of the prior user to sell the product be of much avail if the purchaser were rendered an infringer of the patent by using the purchased product. No doubt one day an inventive patent attorney or practitioner will seek to explore what Section 119 allows and discover whether Caledad is a help, hindrance or irrelevance. The readers of the new issue of the journal that I now launch will not find the answer to that question in its pages, although they'll benefit from being able to read a wealth of scholarly articles of high quality to which the journal readers are fortunate to become accustomed.
Hello, my name is Andrew Lynch and I'm the Dean of the Faculty of Law and Justice at UNSW, and it's my pleasure to give the formal vote of thanks that concludes tonight's proceedings. I express the faculty's appreciation to Justice Rares for his generous remarks in launching Volume 44, Issue 2 of the UNSW Law Journal. Judicial support for the journal has a long history and reflects the high esteem in which this publication is held by the Australian legal profession. I also want to thank Rebecca Gay and the team at Herbert Smith Freehills for being premier sponsor and host of the launch tonight. The faculty greatly appreciates the generous support of the three major sponsors of the journal and the opportunities that this makes possible for our students and the very high quality academic publication that is the result. Our relationship with HSF is one that is valued enormously by the faculty and is manifested through the Herbert Smith Freehills Law Library in our building at the Kensington campus, as well as the rich collaboration that we have forged through the HSF Siebel Centre for China International Business and Economic Law. Thank you so much, Rebecca, for your comments tonight and your support of this issue. I wish to add some brief appreciation of my own concerning the dedication and professionalism of our students. This is especially so over the circumstances of the last 2 years when they've been unable to be on campus and have necessarily had to work remotely to produce the issues of the journal. The office of the journal is, it will surprise no one to hear, perhaps the most frequently occupied at all hours of the day in the faculty. A poster on the door proclaims it to be the province of pedants, and there's obviously nothing wrong with that. But it is one of many disappointments of our current times that the students who who have worked on the journal over 2020 and 2021 have done so without being able to enjoy the intensity of the journal's engine room. This makes more notable the achievement of the current team. They have had all the slog without perhaps as much of the energising camaraderie that comes from in-person meetings and catch-ups. They've managed this deprivation without any interruption or discernible impact on their work. The very demanding job of producing an academic publication, interacting with multiple authors, referees and editors, and all ensuring that the issue comes out on time. This is, we can all agree, a deeply impressive achievement. I congratulate all who have worked on the journal under these circumstances to produce the issue launched by Justice Rares tonight. I particularly acknowledge and congratulate Rebecca Zong as the issue editor. This is a wonderful achievement of which she should feel very proud. The journal has, as its current volume number indicates, a long history. The first issue appeared in 1975, just 4 years after the faculty started teaching. It's important to pay tribute to the journal's significance to the faculty's intellectual life in this, our 50th anniversary year. It also, as an entirely run student journal, reflects the faculty's tradition of student leadership and engagement, which produces graduates with such tremendous initiative, confidence, and verve. It's been disappointing to have much of our anniversary planning disrupted by the resurgence of COVID in recent weeks. But the importance of this milestone is undimmed, and we have, like the journal team, adapted and persevered. A very important part of this has been our fundraising efforts to support student scholarships named after our founding dean, the late Professor Hal Wooten, and 2 of our alumni, Judge Bob Belliere, Australia's first Indigenous judge, and Vanessa Hardman, a wonderful example of the international opportunities our graduates are able to pursue in working with the world's very best. Information on all 3 of these scholarships is available on the faculty's website on the 50th anniversary page, which also features alumni profiles and a fascinating photo reel. I encourage those of you who have not been to the faculty for a while and want to know more to please log on and have a look. Anniversaries are about the future as much as they are about the past, and the scholarships are a reflection of this. The UNSW Law Journal has, I'm sure we agree, a very bright future as the faculty moves forward into its second half century. This is in no small part due to the generous continued sponsorship of the profession, but also the strength and extraordinary commitment of our student body. Again, I thank Justice Rares for his involvement tonight and officially launching this issue, and also Rebecca Gay for the generosity of HSF. Congratulations again to Rebecca Zong, the executive under the leadership of Tina Wu, and all members of the journal's editorial team for this accomplishment. Well done, and thank you.
Thank you to Justice Rares for providing that wonderful keynote speech. This brings our proceedings to a close. Congratulations again, Rebecca, and thank you to all of our viewers who joined us tonight. All the articles of issue 44.2 can be found on our website at www.unswlawjournal.unsw.edu.au, and I hope to see you again soon at the launch of issue 44.3.